Congratulations to both of our mock trial finalists on your accomplishments. It's a great achievement to make it to this championship round, and you should all be very proud of yourselves. I know your team and your teachers and parents and everyone in your community is very proud of you. So that was my very quick introduction because I want to leave time for the judge panel to introduce themselves. So again, welcome to the championship. I'm going to let the panelists introduce themselves and we'll let you begin the trial you're all eagerly awaiting. So I'll turn it over to Judge McBride. Thank you.
So we will introduce ourselves. I think we'll start, which way did we say we were going to start? On the right side, okay. Left side, go right ahead.
Good morning, everyone. My name is Dr. Siobhan Nash. I am at the Cleveland Metropolitan Bar Association. At the Bar Association, I'm the Cuyahoga County Coordinator for this mock trial, as well as all of our community programs and our pro bono programs and services. Thanks for having me.
Well, good morning. I'm Michelle Crayons. I have the privilege of serving as the 143rd president of the Ohio State Bar Association. We serve over 25,000 members in both judges and attorneys, which I hope as I look through this room, we'll see many of you somewhere else down the line. My day job is a trial lawyer. I am a trial lawyer with the firm of Zoll & Crayons in Toledo. We principally represent national class actions and mass torts in the environmental, medical, and pharmaceutical device cases.
I think I turned it off rather than on. So I've made the first goof of the day, so all of you can be a little less nervous. My name's Daniel Strunk. I am a legal analyst for a financial institution, but I'm also a member of the Ohio Case Writing Committee and have been for the last, I think this is my 5th or 4th year. So everything you've ever hated about the cases, you can blame on me. And anything that was good in the cases, you can give credit to the person to my right, who's also on the case committee. I also competed in high school mock trial in Ohio and was in your shoes in 2009 and 2010. So have fun and good luck.
Good morning, all. My name is Ebu Taiwo. I'm a federal prosecutor based in Cincinnati. As Dan mentioned, I was also on the case committee, and I competed in mock trial as, well, I think from 10th to 12th grade. So congratulations to you all on making it to this level. You should be really proud of yourselves. So good luck.
And my name's Jerry McBride. I'm on the competition committee for the mock trial. Was a judge for 31 years in Claremont County, first in municipal court, then in common pleas court. The last 3+ years, I've been a retired judge taking cases by assignment and have been involved in mock trial, I think, since 1995. And a great admirer of the program. So we're looking forward to hearing what both teams do today. Did I give the bailiff a chance to call the court to order? Well, why don't you go ahead and do that?
All rise. Hear ye, hear ye. The Cardinal County Common Pleas Court Harmony, Buckeye, is open pursuant to adjournment. All having business before this honorable court draw near, give attention, and you shall be heard. You may be seated.
Thank you very much. Before we begin trial, I have a brief message to share with today's participants. We all have feelings, assumptions, perceptions, fears, and stereotypes about others. Some biases we are aware of and others we might not be fully aware of, which is why they are called implicit biases or unconscious biases. As participants in the Ohio Mock Trial Program, it is important to resist jumping to conclusions or acting upon personal likes or dislikes. Resist letting bias, prejudice, or public opinion influence your behavior inside or outside of the courtroom. Treat all individuals with respect, regardless of ability, gender, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Now, if the bailiff would swear in the witnesses.
Will all witnesses and parties who are to give testimony in these proceedings please step to the front.
Thank you. Are counsel on both sides ready to proceed?
Yes, Your Honor.
Yes, Your Honor. Counsel for the state, you may make your opening statement then.
Yes, Your Honor. Before I do so, may I introduce myself and my team?
You may do so.
Good morning, Your Honors. My name is Ben Ehlers, and I, alongside my co-counsel, Hannah Madison,
Good morning, Your Honors.
will be representing the prosecution. We will be calling 2 witnesses today. First, you will hear from Makani Kekoa, portrayed by Melissa McMahon.
Good morning, Your Honor.
And second, you will hear from Harley Diallo, portrayed by Joel Bloom.
Good morning, Your Honor.
Our timekeeper and bailiff is Caroline Yance.
Good morning, Your Honors.
With that, the prosecution is ready for opening statements.
You may proceed.
Your Honors, opposing counsel, may it please the court. The defendant, Ash Espinosa, took action. Today, he needs to take accountability. We are here today because the defendant embezzled $80,000 from Trillium High School and orchestrated a scheme to launder an additional $320,000. This money was laundered through Diallo's scrap and sale, a junkyard he co-owned with his cousin, Harley Diallo. Both pled guilty to their crimes. Today, you will learn the defendant had the ability to orchestrate the scheme because he had access to Trillium High School's funds, and he took action. The state is seeking the forfeiture of the defendant's 1967 Chevy Camaro as restitution for his crimes. There are 2 issues in this case. The first issue is whether the defendant is the conspiracy leader. The defense has argued that the defendant is only responsible for the $80,000 he embezzled from Trillium High School. However, pursuant to Honeycutt v. U.S. and U.S. v. Leyva, a conspiracy leader is responsible for the entire amount of a conspiracy's loss. We have the burden of proving to you, by a preponderance of the evidence, that the defendant is the conspiracy leader. And we will meet our burden. Because it will be clear it was the defendant who took action. The second issue in this case is whether forfeiture of the defendant's Camaro is in violation of his Eighth Amendment rights. The Eighth Amendment to the United States Constitution provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted. The Indiana Supreme Court in Indiana v. Timms explained that forfeiture of property that is grossly disproportionate to the offense committed is an excessive fine. The state has the burden of proof by clear and convincing evidence, but they will fail to meet their burden because the evidence will show the restoration of the Camaro was shoddy at best. Forfeiture is not an excessive fine. To meet our burden, we will be calling 2 witnesses today. First, you will hear from Makani Kekoa, a detective with the Harmony Police Department. She will explain to you all the evidence that establishes the defendant as the conspiracy leader. She will explain that it was the defendant who had the financial sophistication to orchestrate this scheme. Second, you will hear from Harley Diallo. He will explain that this entire scheme was the defendant's idea. The defendant created the fake invoices to Trillium. The defendant had access to Trillium High School's funds, and the defendant brought in another criminal to launder more money. We will meet our burden, and the defense will fail to meet theirs, because the evidence will show that the defendant took action. And today, he needs to take accountability. At the end of this trial, my co-counsel, Hannah Madison, will respectfully request that this court order the forfeiture of the defendant's Camaro. Thank you.
Defense counsel, you may introduce your team members and make your opening statement.
Thank you, Your Honor. Once again, Your Honors, my name is Charlie Height, alongside my co-counsel.
My name is Rachel Greer.
I would now like to allow my witnesses to introduce themselves.
Good morning. My name is Gavin Bailiff. I will be portraying Presley Aoki today.
My name is Logan Adams, and I will be portraying Ash Espinosa.
May I proceed?
You may proceed.
Opposing counsel, may it please the court. Initially, Ash Espinosa went along for the ride with Harley Diallo. But in the end, Ash Espinosa was taken for a ride. For a number of years, Harley Diallo owned and operated a successful and financially viable scrapyard business. However, in the year 2020, when COVID hit, Diallo's business took a huge blow, and he coerced his cousin, Ash Espinosa, into coming to work at the scrapyard. He promised Ash a 20% stake in the business in exchange for his efforts, and went as far as to introduce Ash to some of his criminal associates. He conned Ash into an embezzlement scheme and even facilitated further transactions with those illegal participants. However, when the scheme unraveled and police raided the scrapyard, Diallo did not hesitate to throw Ash under the bus, pinning the entirety of the blame for the scheme on Espinosa himself. At this point, Espinosa has forfeited $19,500 in personal assets on top of his 20% stake in the business, leaving only $18,500 in restitution owed to the state. You will later hear from Ash Espinosa, who will testify to how his involvement in the case was only minor, and how he worked to embezzle funds after near demands from Harley Diallo. He will also testify to Diallo's leadership in planning and executing this scheme, as well as Diallo's involvement with known criminals. The Fifth Circuit Court of Appeals case, United States v. Betancourt, ruled on a number of factors which constitute a participant in an embezzlement scheme as a leader. The three which we will focus on, which prove Diallo as the leader over Espinosa, are as follows: their decision-making authority, their recruitment of accomplices, and their claimed right to a larger share of the profits. All of which will prove that Diallo was the leader and that Espinosa was simply a subordinate to this scheme. The second burden which the court will address today is whether or not the taking of Ash Espinosa's treasured 1967 Chevrolet Camaro was an excessive fine under the Eighth Amendment. The defense will prove today by clear and convincing evidence that this was not an excessive fine. That it was an excessive fine. You will later hear from Presley Aoki, who will testify to the magnificent 90% original parts restoration of Ash Espinosa's Chevrolet Camaro. He will testify to his conservative valuation of $83,000, leaving room for an even higher valuation for the right bidder. At the conclusion of today's hearing, my co-counsel, Rachel Greer, will petition the court to rule in favor of the defense, asking that you rule both that Ash Espinosa was not the leader of a conspiracy to embezzle money, and secondly, that the taking of Ash Espinosa's 1967 Chevrolet Camaro Supersport was an excessive fine under the Eighth Amendment. Thank you.
Counsel for the state, you may call your first witness.
Yes, Your Honor. At this time, the state calls Makani Kekoa to the stand.
The witnesses have been sworn, is that correct?
Yes, Your
I just
Honor.
wanted to make sure. Okay, thank you.
Please state your name for the record.
Good morning. My name is Makani Kekoa.
What do you do for a living?
I'm a detective with the Harmony Police Department, specializing in financial crimes. I deal with cases involving embezzlement, money laundering, tax fraud, and similar offenses.
How long have you been with the Harmony Police Department?
Believe it or not, 13 years. I started out as a patrol officer, and I've worked as detective for the past 8 years. I was actually recommended for the position due to my unique educational background.
What is your educational background?
I double majored in accounting and criminal justice from Buckeye University. After I obtained my degree, I passed the exam to become a certified public accountant, and I worked as a CPA right up until joining the force. It was actually during that time that I was able to be involved in a law enforcement investigation while helping out with the financial investigation.
Have you received any additional training since joining the force?
Of course. I've received training through the FBI in the field of forensic accounting. That way I was able to apply my knowledge as a CPA to the world of white-collar crime.
Do you use that training in your everyday work as a detective?
I do. Through that training, I learned to sift through business records and find discrepancies in missing information. I spent a lot of time looking at sample records and reconstructing paper trails to be used in court.
Your Honor, at this time, the state tenders Makani Kekoa as an expert in forensic accounting pursuant to Rule 702.
Is there any objection?
No objection at this time, Your Honor. We just ask that we do retain the right to object to any questions that may be outside of the scope of that expertise.
Certainly. The witness will be so recognized.
Yes, Your Honor. Detective Kekoa, how are you involved in today's case?
Well, in early 2022, I was called in to be lead detective in the Diallo Espinosa case after Trillium High School auditors alerted my department that $80,000 had gone missing. I immediately began investigating the treasurer of Trillium High School, Ash Espinosa, and upon learning about his business relationship with Harley Diallo, I then expanded the scope of that investigation to include Mr. Diallo as well.
Did your investigation lead to an arrest?
It did. Both Harley Diallo and Ash Espinosa were charged with embezzlement and money laundering.
Well, let's start with the embezzlement. Can you explain to the court what embezzlement involves generally?
Yes, ma'am. Embezzlement typically involves a bookkeeper using company funds to pay off personal debt or to fund lifestyles that they generally can't afford. This is usually done by them taking an invoice and changing the billing information on said invoice so that the money is deposited into their personal accounts.
How about the money laundering? What does that mean exactly?
Well, money laundering is a little different. That occurs when dirty money from a crime such as embezzlement is cleaned in order to make it look legitimate. This is typically done by moving that money through a legitimate business to pay for a, say, good or service that isn't actually rendered through that business.
I'd like to walk through the steps you took during your investigation. What initially led you to suspect that Mr. Espinosa and Mr. Diallo were involved in this conspiracy?
Well, as part of my investigation, I conducted surveillance, both at Trillium High School and at Diallo Scrap and Sale, due to their business relationship and the missing funds. It wasn't very long after that I began to see some unusual activity occurring between Mr. Diallo and Mr. Espinosa.
What kind of unusual activity?
They would oftentimes come and go from the junkyard at very odd hours, oftentimes having conversations right at the front gate. It was through my surveillance that I overheard them talking about their money laundering scheme.
Did you overhear anything to indicate who was orchestrating that scheme?
I did. Through my surveillance, I overheard Espinosa tell Diallo about transfers that he had made from Trillium High School into the junkyard's accounts. I also heard Espinosa ask Diallo on if he had followed his instructions on how to invoice Trillium to cover up that crime.
Objection, Your Honor. Hearsay.
May I respond?
You may.
Your Honor, the statements that Detective Kekoa is testifying to are statements by Ash Espinosa, and pursuant to Hearsay Rule 801D2, these statements are not hearsay as they are admissions by a party opponent, and Ash Espinosa is the other party in today's case.
You have any response?
Your Honor, this is a statement that is being offered for the truth of the matter asserted, so I stand by my objection that this is hearsay.
May I respond?
Yes.
Yes, Your Honor. Once again, pursuant to Rule 801D2, even though these statements are being offered for the truth of the matter, they are not hearsay because they are admissions by a party opponent.
Objection is overruled.
Did you find any records of those transactions that Espinosa mentioned?
I did. I found evidence of those invoices through my investigation.
Your Honor, may my co-counsel approach opposing counsel with a clean and unmarked copy of Exhibit F?
You may.
Let the record reflect that my co-counsel is approaching opposing counsel with a clean and unmarked copy of Exhibit F, and may he approach the witness with the same.
He may.
No objection, Your Honor.
Okay.
These exhibits have already been admitted into evidence. Detective Kekoa, what has my co-counsel just handed you?
This is one of those invoices that I mentioned that I discovered early on. As you can see, this one specifically indicates a sale of scrap metal from Diallo Scrap and Sale to Trillium High School for $3,000 on November 10th, 2020. The date of the first unexplained withdrawal from Trillium.
Based on your expertise in forensic accounting, what specifically about this invoice led you to conclude that it was fraudulent?
Well, for starters, it was a little shady that Trillium High School was purchasing scrap metal. But even more suspicious is the fact that Diallo Scrap and Sale's record of tracked scrap parts doesn't corroborate with this invoice. There's no record of these parts coming or going.
Detective Kekoa.
Objection, Your Honor. Improper expert opinion. There was no basis for the opinion or reasonable degree of forensic accounting certainty placed on that opinion from detective.
May I respond?
You may.
Your Honor, this witness has been tendered as an expert in forensic accounting. She has testified that she had training from the FBI in that field. She knows how to go over paper trails and how to go over financial records like these ones to identify fake transactions. And the witness just testified as to why she concluded that this specific invoice was fraudulent.
May I respond, Your Honor?
Yes.
Regardless of whether or not Detective Kekoa has been tendered as an expert, under Evidence Rule 705, they must provide a basis for their expert opinion as well as holding their opinion to a reasonable degree of, in this case, forensic accounting certainty, and they failed to do either of those. So I ask that this is stricken from the record as an improper expert opinion.
May I respond?
The objection is overruled.
Yes, Your Honor. Detective Kekoa, can you read what it says at the bottom of this invoice?
Absolutely. The bottom of this invoice says, if you have any questions concerning this invoice, contact Ash Espinosa.
Were there any other invoices sent to Trillium from the junkyard?
There were not. However, through my investigation, it became clear that Espinosa eventually moved on from creating new invoices and switched to paying off pre-existing ones, diverting payments into the junkyard's accounts. That way, this entire scheme looked legitimate from the school side.
What was the total of those fake transactions?
After I matched fraudulent withdrawals from Trillium High School with deposits into the junkyard's accounts, it totaled $80,000. The exact amount of missing funds, all laundered through the junkyard.
Detective Kekoa, throughout the course of your investigation, did you ever find any evidence to indicate that Mr. Diallo was initiating those transactions?
No. Through my investigation, it was clear that all of the payments were initiated in Ash Espinosa's capacity as treasurer of Trillium High School.
Did you discover any evidence of money laundering from other sources?
I did. In April of 2022, during my surveillance, I overheard a conversation involving Harley Diallo, Ash Espinosa, and someone that goes by the name of Bargain Buddy, who is currently under investigation through the Harmony Police Department for financial crimes. During that conversation, they agreed to launder Bargain Buddy's money through their junkyard for a 20% cut.
Did you find any records of similar transactions?
I did. I found invoices relating to those transactions as well.
Your Honor, may my co-counsel approach opposing counsel?
Yes.
Let the record reflect that my co-counsel is approaching opposing counsel with a clean and unmarked copy of Exhibit G, which has already been admitted into evidence.
Once again, no objection, Your Honor.
Okay.
May my co-counsel approach the witness?
He may.
Let the record reflect that we are handing the witness a clean and unmarked copy of Exhibit G. Detective Kekoa, what have you just been handed?
This is one of those invoices in relation to those other laundered funds. As you can see, this one is payable to Red Brick Holding, LLC, and through my expertise in forensic accounting, it became clear that this was a fake company.
Did you find any similarities between this invoice and the one we looked at earlier?
I did. If we look at this invoice, it is identical to that invoice we looked at earlier in the sense that at the bottom of both of them, they say if you have any questions concerning this invoice, contact Ash Espinosa.
Detective Kekoa, throughout the course of your investigation, did you ever overhear Mr. Diallo engage in conversations about embezzlement or money laundering outside the presence of Mr. Espinosa?
No. Through my investigation, it was very clear that Ash Espinosa was the one with the financial background and sophistication to orchestrate this scheme. He was always present for conversations involving the embezzlement and the money laundering.
Thank you, Detective Kekoa. Your Honor, I have nothing further.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Detective Kekoa, you believe yourself to be the most qualified at the department to handle financial crimes. Would you agree?
Yes, I am the most senior person in our department relating to those crimes.
However, you took the CPA or Certified Public Accountant exam 13 years ago. Is that correct?
That sounds about right, but I work with that field every single day of my life.
But you haven't worked as an accountant formally in more than 11 years. Is that correct?
No, not as an accountant, but I'm a detective in the field of financial crimes.
Now, in the year 2022, you took over the Harley Diallo embezzlement case. Is that correct?
Yes.
And as a part of that, you went to investigate multiple people involved with the case. Is that correct?
I did. I wanted to make sure I did a holistic investigation.
And one of those people was Ash Espinosa, yes?
He was, yes.
And you went as far as to investigate other parts of Ash Espinosa's life, including their second place of employment, yes?
Yes, and that is because the money, we found that the money was embezzled from Trillium High School and laundered through the junkyard, and Ash had connections to both of those places.
And at that point, Ash Espinosa was your lead suspect. Would you agree?
He was, because he was the only person with that access to both places where the crime was occurring.
Your Honor, I ask that everything after the word yes is stricken from the record as non-responsive.
May I respond?
Yes.
Your Honor, everything that the witness stated was within the scope of his question. She was simply elaborating to explain her decision-making process during her investigation.
May I respond?
Sure.
Your Honor, I posed a yes or no question, and I believe the scope of that answer would be confined to a yes or no.
May I respond?
One more time.
Yes, Your Honor. I believe the question was that Ash Espinosa was her prime suspect. She was simply explaining why he was at that point during her investigation.
Objection will be overruled.
Yes, Your Honor.
Now, during your surveillance at the junkyard, you recall an instance of conversation between Harley Diallo and Ash Espinosa, correct?
Multiple conversations, yes.
And during that conversation, they discussed Trillium funds.
Yes, during one of those conversations they did.
And based on that one conversation, you labeled Ash Espinosa as the head of the operation, yes?
Well, that was the key piece that we needed to establish that he, in fact, was in connection with that. So he was my main suspect at that time.
But to clarify, that meant that you believed he was the head of the operation at that point, is that correct?
Yes, because he was the only person with connection to places where the crime was occurring.
And you witnessed no further conversations between exclusively Harley Diallo and Ash Espinosa, correct?
Well, I underwent surveillance for multiple months. I don't believe I specifically stated every single one of those conversations, so I did hear multiple conversations.
In your statement, Detective Kekoa, you don't mention any other conversations between exclusively Diallo and Espinosa, is that correct?
As I said, I didn't mention every single conversation, but I did conduct surveillance for months.
Now, you also recall another instance of conversation between Harley Diallo, Ash Espinosa, and a criminal which is known to your department as Bargain Buddy, correct?
Yes.
And during that conversation, you watched Ash Espinosa look to Harley Diallo and ask, "What do you think?"
He did. All three were participating in speaking during that conversation, and I do recall Espinosa asking that question.
Now, you never believed Harley Diallo to be the mastermind behind the crime, is that correct?
No, I didn't, and that's because Espinosa apparently and clearly had more of a sophisticated understanding of the crime.
However, Ash Espinosa was your lead suspect from the very beginning, yes?
He was. I did expand the scope of that investigation, but he remained the lead suspect because of his knowledge of the crime.
And throughout the entirety of your investigation, he remained your lead suspect, is that correct?
He did.
And you have no explicit transactional links between Ash Espinosa and Bargain Buddy, do you?
Well, we do have this fake invoice that we looked at earlier with Exhibit G. Sam Samuelson is in connection with Bargain Buddy, and
Detective
because
Kekoa, I'm asking if you have any explicit links between Ash Espinosa and Bargain Buddy.
Yes, I'm explaining that Sam Samuelson we believe to be in connection with Bargain Buddy, and because this invoice mentions both him and Ash Espinosa at the bottom, these were parts of the connections that we found.
But Detective Kekoa, Sam Samuelson is not Bargain Buddy, correct?
No, but he works with Bargain Buddy.
Now, you also spent the majority of your investigation pursuing Ash Espinosa. Would you agree with that?
As I stated earlier, yes, because he was my main suspect.
So you would say you spent relatively minimal time looking at Harley Diallo, correct?
Well, I did conduct surveillance 50-50 at Trillium and Diallo Scrap and Sale, so I would say that it was even.
But the majority of the time that you were at Diallo Scrap and Sale, your focus was Espinosa because they were your lead suspect. Would you agree?
It was Espinosa and Diallo. As I said, I expanded the scope of that investigation.
Understood, Detective. Now, throughout your conversations with during the conversation that you witnessed with Ash Espinosa, Harley Diallo, and Bargain Buddy, you never witnessed any more interactions between those three people exclusively. Is that correct?
That's right.
Your Honor, at this point, I have no further questions.
Okay. Any redirect?
Yes, Your Honor. Detective Kekoa, you were asked on cross-examination about the conversations you overheard at the junkyard. Throughout the course of your surveillance, who did you hear initiating conversations about money laundering and embezzlement?
Ash Espinosa.
Thank you, Detective Kekoa. Your Honor, I have nothing further.
Any recross? Very briefly, Your Honor.
Detective Kekoa, just to clarify, the conversations that you witnessed at Diallo Scrap and Sale were between Diallo and Espinosa, correct?
Yes, they were.
And you would agree with me that it takes two people to plan that scheme, yes?
I'm sorry, can you repeat your question?
It takes two people to have a conversation and plan a scheme, correct?
Well, yes, both parties pled guilty to embezzlement and money laundering, so they were both involved, yes.
And you would agree that as a detective with many years of experience in this field, it is not necessarily always the person to initiate conversation who ends up leading the scheme. Yes?
Well, not in every situation, but in this situation, that was the case.
That was what you believed.
Yes, through my surveillance and investigation.
No further questions, Your Honor.
Okay. You may step down.
Your Honor, may I retrieve my exhibits from the witness stand?
You may do so. Does the state have any additional evidence?
Yes, Your Honor. The prosecution calls Harley Diallo to the stand. May I proceed?
You may.
Please state your name for the record.
My name is Harley Diallo.
Mr. Diallo, what do you do for a living?
Well, currently I'm unemployed. And that's because I'm imprisoned. It's a long story.
Why are you imprisoned?
I'm not proud of it, but I got involved in a money laundering scheme with my cousin, Ash Espinosa. You see, we owned a junkyard together until it was seized by the state, and we used it to launder money. I pled guilty, and here I am today.
Did you enter into a plea agreement?
Yes, I did.
Your Honor, may my co-counsel approach opposing counsel?
Yes.
Let the record reflect that my co-counsel's approaching opposing counsel with clean and unmarked copies of Exhibit A.
No objections, Your Honor.
Record will so reflect.
May my co-counsel approach the witness?
Yes.
And let the record reflect my co-counsel's handing that same exhibit to the witness. Mr. Diallo, is this an accurate copy of your plea agreement?
Yes, my signature appears on it.
Can you explain to the court why you're here testifying today?
Absolutely. You see, on the 4th page of the agreement, in the 2nd paragraph, it outlines that in agreeing to this agreement, I will testify truthfully and completely about my crimes
Objection.
whenever asked.
Yes.
Pursuant to Rule 608, opposing counsel is attempting to bolster the witness's character and truthfulness, which is prohibited as it has not been attacked yet.
May I respond?
Yes.
Your Honor, I'm simply laying foundation as to why Mr. Diallo is here testifying today.
May I respond?
Yes.
Your Honor, opposing counsel is laying foundation as to why Harley Diallo is here testifying truthfully today. This cannot be presented as evidence yet, as I have not attacked his character on cross.
May I respond?
Yeah.
Your Honor, all witnesses have been sworn in. It's understood that they're all testifying truthfully. This question is simply to lay foundation as to why Mr. Diallo is appearing in court today.
Let me hear your question again.
Mr. Diallo, can you explain to the court why you are here testifying today?
Overruled.
Were you able to finish your answer?
Yes, I was.
I'd like to talk about the conspiracy at issue today. First, can you explain to the court a little bit about your relationship with your cousin, Ash Espinosa?
Like I said, he's my cousin. You see, we grew up together and were really close. Inseparable, you might even say. That was until high school when our paths went different ways. He was more into books and studying, while I was more into money, and regrettably, I was into chasing girls too. I've grown up since then, but at this point, he went off to college, and I opened up the junkyard.
Mr. Diallo, earlier you said that you and Mr. Espinosa were co-owners. Did he open the junkyard with you?
No. After graduating from college, Ash went on to become the treasurer of Trillium High School, and he kept his son, Oakley, close by, because they lived in Harmony, because I'm based out of Harmony, and we all love cars, so they'd come around the junkyard, and we'd just stay close.
How did Mr. Espinosa become involved in the junkyard business?
It all happened when the
Objection,
pandemic
Your
hit.
Honor. Leading
Yes.
question. May I be heard?
Yes.
Opposing counsel asked how Ash Espinosa got involved in the junkyard business. It has not yet been established, or foundation has not been laid, that Ash Espinosa was involved with the junkyard business itself.
May I respond?
Yes.
Your Honor, earlier you heard Mr. Diallo testify when I asked him why he is in prison, that he was involved in a conspiracy where he co-owned the junkyard with Ash Espinosa. Additionally, 2 questions ago, I asked if he opened the junkyard with him, and he said no, that happened later, implying that Mr. Espinosa was involved with the junkyard later.
My objection stands, Your Honor.
Okay, overruled.
How did Mr. Espinosa become involved in the junkyard?
It all happened when the pandemic hit. You see, Ash's job as treasurer got reduced down to part-time. But he had a family to support, his wife, his son, so money was tight for him. He came to me and I did offer him some shifts at the junkyard to try and bridge that gap, even though my business was also hurting.
Earlier, Mr. Diallo, you said that Mr. Espinosa was a co-owner. How did picking up some shifts lead to being an owner of the junkyard?
To tell you the truth, I've never been financially savvy. So after Ash had been working with me for about a month, I asked him to take over more of the business end of things. Because he had that degree in something finance related from his time in college, so it made sense to me, and I needed that help. He said he'd only do it if I gave him an ownership interest, and I had no other option, so I gave it to him.
Did your business improve after Mr. Espinosa became involved?
In the beginning, yeah. But then in November of 2020, our car mover broke. Now, that's the big claw that picks up and moves junk cars around the junkyard. They don't exactly move themselves, so we couldn't function without it. It turns out it needed a new belt. And that's about $3,000, and that was $3,000 more than we had.
What did you do?
Well, I approached Ash. Proposed some ideas. Maybe we'd mortgage a junkyard, buy the belt on credit, or borrow money from some friends. But he then suddenly suggested that he could get the money from Trillium High School.
How did you react?
I was stunned. I didn't think Trillium would just give him the money, but then he explained that he would take the money and then he'd replace it before the Audi audit. I'm not financially savvy, as I mentioned, but he'd replace it before anyone would notice.
Mr. Diallo, were you aware that what Mr. Espinosa was proposing was a crime?
Yeah. Like I said, I'm not proud of any of this.
Do you know how Mr. Espinosa took the money from Trillium High School?
I don't know the details on the school side of things. I wasn't involved. But what I do know is that he made some fake invoices, and then the next thing, the money was in our account. We got the belt replaced, and we were back up and running again. So I just thought everything was going to be A-okay.
Are you aware of any other times where you and Mr. Espinosa laundered money through the junkyard?
In April of 2022, Ash introduced me to a friend of his, went by Bargain Buddy. Ash then went on to explain to me that Buddy had a problem I could help him with. I thought they were just talking about cars. So I asked about make and model, and then Ash told me Buddy wanted us to launder money for him in exchange for a 20% cut.
Were there any other times where Mr. Espinosa embezzled money from Trillium High School that you're aware of?
Yeah. Ash later told me that he'd been taking small amounts of money from Trillium for months to pay for personal and even junkyard expenses. And I had no idea about this until he told me.
Now, with the laundering from Buddy through the junkyard, do you know where Buddy's money came from?
No, I didn't ask any questions.
Why did you go forward?
I knew I could recoup my losses from the pandemic. And I just thought what I didn't know about the money couldn't hurt me. At least I thought so. So I chose to trust Ash and be willfully ignorant.
Did this scheme expand?
Yeah. Later, some of Buddy's business partners reached out to me and asked us to do the same for them, which we then did.
Was Ash aware of these additional transactions?
Yeah. I told him about it, and all he had to say was he just smiled and said, "Make sure I get my cut."
How long did this scheme continue?
About 4 months. And then in August of 2022, 12th, I believe, officers came to junkyard and they came with a search warrant. They ended up seizing financial records and then Ash's car. And 2 weeks later, Ash and I were arrested.
Thank you, Mr. Diallo. Your Honor, I have nothing further.
Cross.
Yes, Your Honor.
May I proceed?
You may.
Harley, you initially entered a plea of not guilty, correct?
Yeah, that's correct. But then I understood what I did was wrong, and I knew there was a lot of evidence against me.
Right, and you immediately went to work to shorten your prison sentence, correct?
As I think anyone would.
And to do this, you cut a deal with the prosecution, exchanging leniency in your sentencing for you to testify today against Ash Espinosa.
They said they'd propose leniency, but I wasn't guaranteed anything.
More about your relationship with Ash Espinosa. You stated Ash always looked up to you, right?
Yeah, that's right.
And after high school, he went to college and you opened your own junkyard, true?
Yes.
And you successfully owned and operated this junkyard for about 20 years.
Yeah, I mean, I thought it was successful, but then again, we didn't always have the money for the finer things in life, but I was happy.
Yes, you were the sole owner for about 20 years.
Yep, my name was on the headboard.
And when Ash came to the junkyard, you gave Ash a 20% cut of the business, correct?
Yes, to help with the financial side. I really had no other choice but to give him it.
Just to clarify, you continued owning 80% of the business?
Yes.
And as you and Ash were working at the junkyard, a man named Bargain Buddy approached you, correct?
Yeah, Ash introduced me.
And you were admittedly performing money transactions for Bargain Buddy.
Ash and I were.
You both were, correct?
Yes, we were.
And after Bargain Buddy's business contacts began reaching out to you alone.
Yeah, I don't know why they reached out to me.
And you were performing similar money transactions for Buddy's business contacts, true?
Yes.
And you stated you were nervous to tell Ash about these transactions?
I was, but when I did tell him, all he did was smile, say, make sure I get my cut.
But just to clarify, Ash had no knowledge of these transactions until you told Ash.
That's correct.
You were performing these transactions independently from Ash Espinosa.
Yeah, I just did whatever I was told to by Ash previously. I just did the same thing.
But Ash was not telling you to do these transactions for the multiple business contacts that were reaching out to you alone.
He wasn't.
You mentioned your junkyard was struggling when COVID hit.
Yeah,
You stated it was hard to keep up.
absolutely.
Yet you also mentioned you had extra cash to spend on luxuries, like new clothes and camera systems.
Yeah, after I engaged in the later part of the money laundering.
So you were benefiting from this money laundering?
Yes, and Ash was too when he got his cut.
Thank you. No further questions, John.
Any redirect?
Yes, Your Honor. May I proceed?
You may.
On cross-examination, you were asked about your plea agreement. When you entered your plea agreement, were you promised the court would impose a reduced sentence in exchange for your cooperation?
There were no promises. In fact, in the middle of page 2, it says it here. Sentencing was totally up to the court. And then on page 4, in the first paragraph, it outlines how the prosecution may move the court to depart from sentencing guidelines. Well, it's up to their discretion, and then solely up to the court whether to grant the motion. It was clear to me there were no guarantees.
Thank you, Mr. Diallo. Your Honor, I have nothing further.
Any recross?
No recross, Your Honor.
Okay. You can step down.
Your Honor, at this time, may I retrieve my exhibit?
You may.
Thank you.
Does the state have any additional evidence to present?
No, Your Honor. At this time, the state rests our case.
Does the defendant have any evidence to present?
Yes, Your Honor. The defense calls Presley Aoki to the stand. May I proceed?
You may proceed.
Good morning. Could you please state and spell your last name for the court?
Good morning. My name is Presley Aoki. My last name is spelled A-O-K-I.
And would you prefer to go by Presley or Mr. Aoki today?
Presley's just fine.
All right, Presley. Are you employed?
I am.
And what do you do for work?
So I am an IACP certified auto appraiser, and I specialize in valuing cars, specifically classic or project cars.
Now, Presley, how long have you been in the field of classic car appraisal?
So I've been in the business for 24 years now, and let me just tell you first, I've loved absolutely every minute of it. I've gotten to see some amazing cars, project cars, and even other cars. And I've even gotten to see some bad ones in my time, as everyone probably would. I would like to say first that this 67 Camaro does not disappoint.
Okay, Presley, before we get into the Camaro, I'd like to ask a few more questions. Do you have any special or technical certifications within this field?
I do.
And could you elaborate on those for the court?
So again, I'm certified under the IACP, which stands for International Auto Appraiser Certification Program. And that program in of itself consisted of a 40-hour course for auto appraisers wanting to become certified. With that 40-hour course, you had to continue on with a subsequent IACP certified auto appraiser's exam, which I later passed. And with that, the technical certification that I was asking for was mine.
Now, Presley, as an IACP certified auto appraiser, who do you work for?
So actually for me, I work for myself. For the 24 years now that I've been appraising, I run my own business called Aoki Auto Appraisals. AAA for short for everyone. So with that, I'm not really, I just run my own business. I'm the sole employee.
Now, Presley, are there any governing bodies which regulate your field of work?
Yes, there are.
Could you outline those for the court?
So I'm governed by the Bureau of Certified Auto Appraisers Code of Ethics and the Uniform Standards of Professional Appraiser Practice Guidelines. So those in of itself, again, they make sure that every appraiser that I do and every other expert appraiser that is under the IACP is honest in their appraisals.
And do you adhere to those regulations?
Every single time.
Now, Presley, have you ever testified in court before?
Yes, I've testified dozens of times on both the plaintiff and the defense.
Your Honor, at this point, pursuant to Evidence Rule 702, I ask that the testifying witness, Presley Aoki, be recognized as an expert in the field of classic car appraisal based on his 24 years of experience within the field, his business ownership within the field, his education and subsequent certification through the IACP, alongside his regulation within the field.
No objection pursuant to Rule 702.
Witness may testify as an expert.
Thank you. Presley, could you walk us through how you conduct a typical appraisal?
So a typical appraisal is very technical. You have to, go through a step-by-step process. For me, I always have a preliminary conversation with the owner of the vehicle. In this specific case, it was Ash Espinosa and OCLRE. But anyways, I continue on after that with a walk around of the vehicle, looking at the exterior, interior, and under the hood. And then I really start getting involved with the car. And after that, you spend hours and you become with a fair market value.
Now, Presley, is there a uniform standard to how you conduct an appraisal?
So there is a standard, but I like to consider myself and other experts in my field way more technical than that. So.
Now, Presley, in 2022, were you contacted to appraise a vehicle for Ash Espinosa?
I was.
And who contacted you for that appraisal?
So actually you, Mr. Height, and along with Rachel Greer and their office, contacted me to do a thorough investigation of the vehicle.
And Presley, were you paid for your services?
I was.
And how much, if you don't mind me asking, were you paid to be here today?
No problem. So I'm paid $250 an hour for my services. I spent 38 hours on this project alone. And along with being here today, I also charge a $5,000 extra testimony fee to testify as an expert. And that covers travel expenses and everything else that I might need to get here today.
Presley, did you perform an inspection on Ash Espinosa's vehicle?
Yes, I did.
Could you tell us what vehicle that was?
So this vehicle was a beautiful 1967 Chevrolet Camaro, super sport as well.
And could you walk us through what parts as broad categories you inspected with this vehicle?
So every category is different. You have to do different things for each and every category. After my preliminary walk around and conversation with the owners, I looked at the exterior, interior, under the hood, even the underside, and everything else that I might need to look at to get a good fair market value in this vehicle.
Could you explain for the court what you found with the interior of this vehicle?
Man, the interior, I'm just envisioning it now, honestly. I mean, you walked into the door, you sat behind the driver's seat, and you envisioned yourself in 1967. It was insane. I mean, you looked at the front gauges, they still worked. There was no dust on the dashboard, which is kind of important to keep sure the cars are clean. And everything in that car, along with something that I noticed after that, was impressive. I mean, even when I looked over to the side of me and I looked at the stick shift, I realized that this car is not just a 3-speed, but a 4-speed.
Now, Presley, why is it important that this vehicle was a 4-speed and not a 3-speed?
Well, this car itself is already rare. And so seeing that it was a factory upgraded 3-speed to a 4-speed made it even more rare.
Objection, Your Honor. Lack of foundation. May be heard.
Sure.
Yes, Your Honor. There's been no foundation laid for how this witness knows, nor what factors contributed to his conclusion that this is a rare vehicle. He hasn't referenced any market research, any market analysis, in order to testify that this specific 1967 Chevrolet Camaro is a rare find.
Your Honor, Presley Aoki has been admitted as an expert in the field of classic car appraisal. As a part of his work in the industry, he sees cars like this on a daily basis. He has appraised thousands of vehicles in this field, and because of that, he doesn't necessarily need outside research or specific research for this vehicle to know that that is a rare find. That is just part of his base of knowledge.
May I respond?
Yes.
Your Honor, given that the witness is an expert in auto appraisal, the foundation can be laid to show that he may know that this vehicle is rare. However, he cannot just make the blanket statement that this car is a rare find without first disclosing the underlying facts and data that contribute to that statement pursuant to Rule 705.
Objection is sustained.
Yes, Your Honor.
Presley, could you provide some background behind how many of these vehicles may have been upgraded to a 4-speed?
Oh, of course. So this car in specific is a 57-year-old 1967 Chevrolet Camaro. Now, this car, again, only 100,000 of the regular 67 Camaros were made at that time. And then along with that, it gets even more rare when you see that this is a super sport model with the super sport trim. Only 35 of those cars were actually, or 35,000 of those cars were actually made at that
Objection,
point.
Your Honor. Hearsay. May I be heard?
Yes.
Yes, Your Honor. The witness is currently testifying to specific statistics about the amount of Chevrolet Supersport Camaros that were created in 1967. However, once again, there has been no foundation laid for how this witness knows that, no foundation laid that he conducts that market research, and the fact that he is giving these statements, these are out-of-court statements that the witness, these are out-of-court statements that are being offered to prove the truth of the matter asserted, that only so many of this specific Camaro exist.
Your Honor, my witness is attempting to explain multiple of those facts for the court at this point. I believe if he is given a little leeway, he could provide some testimony that would explain how he came upon these numbers, what these numbers mean, and why they are relevant. Additionally, if opposing counsel would like to ask the witness about where he may have derived these numbers, she is entitled to do that on cross-examination.
I'll overrule the objection, but you do need to establish more basis.
Understood.
Yes, Your Honor.
Presley, could you explain for the court how you check different parts within a vehicle?
So for the parts aspect of this vehicle, you have something called cataloging those parts. Now, a catalog is a big, huge book for any type of car that rolls around the road. If you're talking about a 57 Chevy, or if you're even talking about like a 2018 Toyota RAV4, they're all the same in their own way. They have a gigantic book of different part numbers that you have to make sure are relevant to the time period, especially with appraising a car like this. And while you do that, each and every part has to match. And when you catalog those parts, each matched part means more value. So cataloging those parts are very important.
So Presley, could you explain for the court why this vehicle may have been more valuable based on what you found within the catalogs?
So within the catalogs, over 90% of the car was naturally OEM and NOS modified parts. So OEM really means original equipment manufactured parts, which means that for this specific spec, Chevrolet made this equipment, and then after that, it was never really used, and then it was put into the car afterwards. New old stock, something similar, is NOS parts.
And could you explain what an NOS part is?
So an NOS part, new old stock, is when a part is new, but it wasn't actually in the car, it was just old stock parts.
Now, Presley, at this point, could you detail for the court why you believe this vehicle to be rare?
So this specific spec of this car, again, as I was saying before, only 35,000 of the Super Sport Camaros were made in 1967. What makes this car even more rare is the fact that under the hood, it holds a 396 cubic inch V8 engine that produces a little over 370 horsepower. Now,
Objection, Your Honor. I re-raise my lack of foundation objection.
May I respond, Your Honor?
Yes.
The witness has just established that by referencing the catalog, he may come upon both a valuation and an understanding of what parts were included in this vehicle, on top of whether or not they were stock with the vehicle. And based upon that, he can in fact make a conclusion as to the rarity of this vehicle specifically.
May I respond?
Sure.
Your Honor, the witness did go over how he looks at the parts in the vehicle. However, there still has been no foundation laid for how the witness came across specific market trends and how he conducted market research in order to determine the specific rarity of this 1967 Chevrolet Camaro in today's market.
Objections overruled.
Yes, Your Honor.
Now, Presley, could you please once again detail for the court why you believe this vehicle to be rare?
so as I was saying, now to continue on with this specific spec, the 396 cubic inch V8 engine with 375 horsepower, to the average people that is, just numbers. But for me and other appraisals in the world, and other car guys and gals, that is pure American muscle under the hood of that 67 Camaro.
Now, Presley, briefly, could you detail what you found with the exterior of this vehicle?
So the exterior of this car was immaculate, nice and shiny. Everything, even the color, was relevant to the time period of what you would find in 1967. So that was extremely good. No big scratches, no huge dents, which was really important.
Now, Presley, did you conduct this appraisal and this inspection to the uniform standard that you adhere to with your other inspections?
Yes, as I always do.
Now, Presley, if there were to be a 100% original parts restoration of this vehicle, could you give a fair market value for what that vehicle might go for?
Yes, I could.
And what would that value be?
Well, again, considering the rarity of this vehicle, as I continue on saying, only 1,100 of these cars were actually made with the factory upgraded 3-speed to a 4-speed, along with a 396 cubic inch V8 engine, which makes this car a hidden gem for being 57 years old. I would say that this is probably a fair market value of around $130,000.
Objection, Your Honor. Relevance. May I be heard?
Yes.
Your Honor, the witness is currently testifying as to the hypothetical value of another 1967 Chevrolet Camaro that was restored in a way that is different from the Camaro we are here to discuss. The fact that a Camaro restored perfectly would be worth over $100,000 holds no relevance as to the value of the Camaro that we are discussing in today's case.
Your Honor, may I respond?
Sure.
I would like to make 2 points. The first being, as an expert witness in the field of classic car appraisal, Presley Aoki is absolutely entitled to provide an answer to a hypothetical like this, seeing as it is directly involved with his field. Secondarily, this question is laying foundation for a further line of questioning, which will detail why Presley Aoki devalued the vehicle as he did as a part of his appraisal from what a perfect appraisal might have been. So this is contextual for a further line of questioning.
Objections overruled. You'll have an opportunity to examine the witness.
Yes, Your Honor.
Presley, do you have an expert opinion to a reasonable degree of classic car appraisal certainty to the value of Ash Espinosa's 1967 Chevrolet Camaro?
I do.
And what is that opinion?
Considering all the variables, the rarity of the car, the parts that were used, all the parts that weren't used, the 10% that was missing from the OEM NOS parts, I would say that there is a fair market value of $83,000.
And briefly, what is the basis of that opinion?
So the basis of this opinion is as follows. You looked at the car, you spend 38 hours like I do on this specific spec, and you look inside of it, again, you catalog those parts, you do a lot of work to figure out the fair market value of each and every part that goes into the car, besides, tearing the whole engine apart. You're not going to tear apart a whole big block Chevy, but you look at all of these parts put together and you are able to develop a fair market value of $83,000.
Thank you, Your Honor. No further questions.
Cross-examination.
Yes, Your Honor. Well, Mr. Aoki, as you stated on direct examination, you're an auto appraiser?
I am.
Before becoming an auto appraiser, you tried to become an automotive service technician.
Well, I did some college work at Buckeye State to become an automotive service technician. And with that, I didn't exactly like that job. I was getting covered in grease, getting frustrated at lug nuts trying to come off of wheels right, or even pieces of, equipment falling into the engine bay. It was all frustrating. Again, I still loved cars. So with that being said, I moved over to becoming an IHCP certified auto appraiser where I could still admire these amazing pieces of equipment.
Well, Mr. Aoki, I'd just like to clarify, you stated that you didn't like that job. However, you never became an automotive service technician.
Well,
Objection, Your Honor. Relevance.
May I respond?
Yes.
Your Honor, the witness stated that he didn't like having the job of being an automotive service technician. I'm just establishing for the court that he never actually completed his education and was never actually a mechanic, and this goes to the witness's credibility in today's case.
May I respond?
Yes.
Presley Aoki is here today to testify to the value of Ash Espinosa's vehicle and provide a basis behind why he assigned the value to that vehicle. Whether or not he completed a service technician certification much earlier in his career has no bearing on whether or not he can provide accurate testimony to the value of this vehicle in today's case.
May I respond?
Yes.
Your Honor, on direct examination, the witness went into great detail about the specific parts in the Camaro and the extent to which they were restored. During his evaluation, he was examining the work of mechanics. Therefore, the witness, cross-examining the witness on his knowledge of mechanic techniques is absolutely relevant and goes to his credibility.
Your Honor, may I respond?
Yes.
I would ask that opposing counsel then restrain her line of questioning to asking about the techniques and not necessarily him completing his education or his certification.
I'll allow the further cross-examination.
Yes, Your Honor. So just to clarify for the court, you never actually worked as an automotive service technician.
Oh, I mean, if I did work as an automotive service tech, I'm sure I probably would have hated life. So to that extent, I decided not to continue my further work as a AST, as they say.
You were never a great mechanic.
Well, that was also continuing with my frustration. And I still loved cars, and I still loved how they worked. And with that being said, I moved over to becoming an IACP certified auto appraiser.
Well, I'd like to talk about your work in today's case. You were retained by counsel for Ash Espinosa to determine the value of his 1967 Chevrolet Camaro.
Yes, I was, asked to do a appraisal of this vehicle, but I wouldn't really say retained.
Well, Mr. Aoki, you were paid for your work in this case, correct?
I am.
As part of your evaluation, you interviewed Mr. Espinosa and his son.
Briefly.
And they told you that the parts in the car were in good condition.
That was later confirmed when I did my auto appraisal. Spent 38 hours on that, and I later confirmed that.
They told you that the car had never been in an accident.
Well, with that being said, you gotta do some work outside of what they say. I'm not going to take anyone's word for it. That's why I am an auto appraiser. That's why I've spent 24 years of making sure that I'm doing it the right way. And I later confirmed that the car does not look like it has been in any type of accident. The body panels are still relevant, and they're still the same thing that was on the car 57 years ago.
Well, Mr. Aoki, you said that you verified this by looking at the car, but you didn't reach out to the car's previous owners.
Well, there was really no way, but I don't normally do that to an extent because of how old some of these classic cars are. This car specifically came from the junkyard itself, and there was no real way to talk about that.
So you didn't attempt to look into the car's history?
No, I did not.
You did, however, inspect the vehicle.
I did.
The car had undergone significant repairs.
Yes, it started. I have no idea actually how it started to an extent. I mean, but what the car shows, it speaks for itself. I'm here to talk about that in specifics. This is a beautiful car.
Now, you would agree with me that the quality of a restoration ultimately determines the value of a vehicle.
I would say so. And for this specific spec, it was really incredible. I mean, 90% of this car was made with OEM and NOS parts, which are very important for value. And, there was no real huge problems other than the 10% that were not OEM and NOS.
Right, I'd like to talk about those parts. You believe that one key detail of a quality restoration is the source of the parts used.
Yes, that is correct.
When you examined the Camaro, you found that some of the parts were not a perfect match.
Yes, and I devalued that with whatever is customary to that devalue.
The parts were not the highest quality?
No, and for a 57-year-old car, you'd have to have some pretty deep pockets to make sure that this is the highest quality.
You don't know where those parts came from.
Objection, Your Honor. Asked and answered.
May I respond?
Yes.
Your Honor, my previous questions were about the quality of the parts and whether or not they were a perfect match for the vehicle. This question is asking the witness whether or not he knows the source of those parts.
I believe he's already testified to that, Your Honor.
Overruled.
Yes, Your Honor. You don't know where those parts came from.
Well, other than the numbers that match the catalogs, no, I do not know where they came from, but I am certain that they came to do the same thing that every other part does.
So that's a yes, you don't know the source of those parts.
No, I do not.
You weren't present at any point during the restoration process?
As a certified auto appraiser, rarely am I ever present for the restoration process. I am here to appraise vehicles. I'm not here to work on them.
You didn't personally observe Ash and Oakley's methods?
Well, again...
Objection, Your Honor. Asked and answered.
May I respond?
Yes.
Your Honor, the witness answered my previous question as to whether or not he was present for the restoration in terms of his general work as an auto appraiser. This question is just narrowing it down to establish that he doesn't know what the defendant's methods were when restoring this vehicle.
Your Honor, the previous question, before that question, was whether or not he was present for the restoration. And if he was not present for the restoration, that means that he also was not present to witness the techniques that were used in repairing this car. So I do believe this question has been asked and answered.
I think it's fair cross-examination. Objections overruled.
Yes, Your Honor. You didn't personally observe Ash and Oakley's methods?
For every other car that I do, rarely do I ever look at, what work has been going into the car. The cars speak for themselves, and I spend as much time as I can looking at these, cars. And that's the same thing that I did with the 67 Camaro Super Sport.
Mr. Aoki, I wasn't asking about all your other appraisals. In this case, you didn't observe Ash and Oakley's methods, correct?
I just said that's the same thing that I did with the Super Sport. I mean, to an extent, I did not have any chance to look at the people doing the work.
There was no indication that they worked with a certified mechanic?
No, but when I looked at the car itself, everything was still relevant to the time period, number matching, and, that speaks value.
So that's a yes?
I suppose.
Mr. Aoki, you've testified in court before today, correct?
I have.
I'd like to talk about one specific case. In one case, you were providing an auto appraisal with a co-counsel that you'd known previously, right?
That is correct.
And during that case, your testimony was thrown out.
Objection, Your Honor. Under Evidence Rule 403, this line of questioning is more prejudicial than probative and goes to attack the character of my witness, not necessarily provide any facts relevant to his ability to provide evaluation today.
May I respond?
Yes.
Yes, Your Honor. This line of questioning is relevant for two reasons. First, Your Honor, if I may make an offer of proof, the testimony that I'm referring to that the witness gave previously was also for an auto appraisal, the same way that it is today. Therefore, the fact that his testimony was thrown out in a previous case where he was appraising a vehicle does go to his credibility in today's case. As for whether this is a question of his character, if I may make another offer of proof, the witness in this case was accused of taking bribes, and taking bribes would be a crime of untruthfulness, and character for truthfulness or untruthfulness is permitted under Rule 403.
May I respond, Your Honor?
Sure.
The issue that she is asking about is just that. It was purely an accusation. Presley Aoki, there is no proof that could be offered today that would show that he did in fact take bribes. And I believe that under Evidence Rule 403, because this is going to attack the character of my witness without reasonable background or proof, is inadmissible.
May I respond?
The cross-examination will be permitted.
Yes, Your Honor. In this previous case, your testimony was thrown out.
It was. And, you know, things got hot in that scenario, and I'm not proud of it, but it happened.
And in that case, you were also appraising a vehicle.
I was appraising a vehicle.
During the case, you were accused of taking bribes.
Though I was accused of taking bribes, I would like to point out that the second appraiser after me that was doing another appraisal had the exact same number as me.
Mr. Aoki, I'm not asking you about the work of another appraiser. In this case, you were accused of taking bribes, correct?
Objection, Your Honor. I ask that my witness be allowed to provide a full answer to the question.
Your Honor, I'm just clarifying for the court.
Witness may provide a full answer.
Yes, Your Honor. You were accused of taking bribes, correct?
As I said, I was accused of taking bribes, but, you know, it did not happen.
You were paid for your work in this case.
As I am every other case.
You were paid $250 an hour for your evaluation?
Yes, and I spent 38 hours of hard work and a lot of time on this service.
You're also receiving a $5,000 flat fee for your time here in court?
Yes, so that is, you know, it is relevant to all other experts in my field. It is customary and reasonable to other experts in my field to have that same fee.
You stated on direct examination that $5,000 goes towards travel expenses and any other expenses that might occur as you make your way to court.
That is accurate.
Mr. Aoki, you reside in Harmony, Buckeye, correct?
I do reside in Harmony, Buckeye, but it wouldn't be relevant to change the price that I have for anyone else based on where I go and don't go.
You're aware that this case is happening in Harmony, Buckeye?
That is, I am aware.
You're being paid $14,500 for your testimony?
That is my price, and for other expert auto appraisers in my field, that is definitely customary and reasonable to other.
Mr. Aoki, I wasn't asking about other auto appraisers. You're being paid $14,500, correct?
I am.
Thank you, Mr. Aoki. Your Honor, I have nothing further.
Redirect.
No redirect, Your Honor.
Okay. You can step down. Do you have any additional evidence to present?
Yes, Your Honor. The defense calls Ash Espinosa to the stand. May I proceed?
You may.
Good morning. Can you please state and spell your name for the court?
How you doing? My name is Ash Espinosa. Espinosa spelled Espinosa.
And Ash, can you tell the court a little bit about yourself?
Yeah. So I grew up in Harmony, but when I was young, my parents sadly passed away in a car accident. God rest their souls. I moved in with my grandmother, but she suffered from a lot of health issues, so I spent a majority of my time with my cousin Harley Diallo's family.
And can you describe your relationship with your cousin Harley Diallo?
I'm happy to say that there was a time where it wasn't as tense as it is now. But when we were younger, we spent a lot of time together. We were really inseparable. We grew to love cars together. And then once high school rolled around, priorities changed, and we kind of grew apart.
And what happened with you after high school?
Well, after high school, I went to the Buckeye State University, got my degree in business, met my stunning wife, Jamie, and was working at a tire manufacturing company for a handful of years until we had our beautiful boy, Oakley, and decided to move back to Harmony.
And how was moving back home for you and your family?
It was pretty smooth sailing. Jamie had gotten a job at a local joint called Pullin' Chicken, and let me just say that they got a killer chicken tender basket. It's a lot better than the food I'm getting right now. But I was reached out to by Harley about an opening at Trillium High School for the position of treasurer. And, you know, I have a degree in business, so I figured I'd hop on that.
And slightly shifting gears, we all recall the COVID-19 pandemic. What was your experience when the pandemic first began?
Well, for me and my family, it was a very tough time, and I think it was for everybody. Jamie had lost a job, and my hours at Trillium and my pay was cut in half. So Harley had reached out to me about picking up work at the junkyard, and to kind of get a little bit of extra cash flow for my family, I decided to start working at Diallo Scrap and Sale.
Now, more about work at the junkyard. Do you recall the events of November 2020?
I do. That was when a belt broke for the car mover.
And now, what, if anything, did Harley Diallo do about the broken belt?
Well, it was a $3,000 belt, so it was a big repair. And I suggested to Harley getting a loan, and they shot down any of my solutions that were legitimate and viable. And they told me that I needed to find money in a creative way, and then brought up my job at Trillium, shooting me these looks. And I was absolutely stunned.
What happened next?
Well, after they had shot down my ideas, they kept bringing up Trillium over and over and over again. And how else am I supposed to interpret find money in a creative way? I get a kind of a nasty look, and then they bring up where I have access to funds and where we could find that money. So that's when we began embezzling from Trillium. I told them that I could make the fake invoices, and they immediately chimed in and said that they could make the fake receivables to cover up our tracks. And I was surprised that they knew how to do that.
So after the broken belt incidents, did any similar incidences occur after this?
Well, that happened in November, and a month later, December, our furnace went out. And if you know Buckeye in December, it's pretty shaky with the weather. So you really can't function without a furnace. And we still didn't have the extra funds laying around, and I knew Harley had already shot down my legitimate and viable ideas to finding the funds to fix any problems that we had. So we made another fake invoice and fake receivable.
After this, did you continue embezzling with Harley Diallo?
For a time, as ashamed as I am to say it, I did. Until December of 2021, I completely cut it off. I mean, we had taken $80,000, and the money that we promised ourselves to repay, we hadn't paid back a dime yet. And I was losing sleep over it. I couldn't do it any longer. So I told Harley that I was done taking money from Trillium, and they didn't bat an eye and said they had other money coming in.
So,
Objection, Your Honor. Hearsay. May I be heard?
Yes.
Your Honor, the witness just testified as to Harley Diallo's statements about other money coming in. This is an out-of-court statement being offered to prove the truth of the matter asserted and is therefore hearsay.
may I respond?
Yes.
Your Honor, pursuant to Rule 801 D2E, this was a statement by a co-conspirator in the furtherance or in the course of the crime. It has already been admitted that Harley Diallo was embezzling funds. Harley making statements about other money coming in is them directly admitting to money laundering and furthering the money laundering crime that we were talking about today.
May I respond?
Yes.
Your Honor, this specific statement did not further the conspiracy. A statement furthering the conspiracy would be, for example, a conversation between Bargain Buddy and Diallo. But this specific statement did not add to the amount of money that was being laundered in this conspiracy. It didn't further the conspiracy. It does not meet this exception and is therefore hearsay.
May I respond?
Yes.
Your Honor, Rule 801 D2E is in furtherance and in the course of the crime. This was during the money laundering scheme. This was directly in the course of the crime.
Objections overruled.
Yes, Your Honor.
After Harley admitted to having other money laundering coming in, Were you aware of them working with anyone else besides Bargain Buddy?
No, I thought that Trillium was the only thing that was happening, and they said that they were making the same receivables for other people and taking a cut. And they even went as far to introduce me to somebody by the name of Bargain Buddy that they were helping out with a dollars and cents problem. And I told them that I wasn't going to touch a dime of Buddy's money.
So since you weren't helping with the conspiracy any further at Diallo's scrap and sale, what were you doing at the junkyard?
Well, I was doing what I was originally doing in the beginning when I first was introduced to Diallo's scrap and sale, and it was just salvaging parts off of cars that would come in and evaluating them, stuff like that.
Just to be clear, who owned Diallo's scrap and sale?
Well, at the time, Harley had insisted and pretty much forced me to take a 20% cut after I had helped him out, and this was early. And then Diallo continued to own the other 80%. I mean, it was still Diallo scrap and sale, not Espinosa scrap and sale, and they were the boss.
Right, so talking about the 1967 Chevrolet Camaro, when did this car come into the picture?
We saw it roll into the lot August of 2021, and, you know, growing up loving cars, it was my dream car. And my boy Oakley kind of followed me around the junkyard here and there, grew to love cars too. And the second it rolled in, I knew it was a good find, and I thought to myself this would be a perfect father-son project. And, you know, COVID was a tough time, especially for teenagers, and I knew that this would kind of be a light in all the darkness.
So how did you purchase this vehicle?
Well, again, money was tight since it was COVID, but I took a look at the family finances, and I figured out that I could squeeze $500 out of my next 2 paychecks coming directly from Diallo scrap and sale. There's a little bit of extra cash we had coming in. So we decided to purchase the car, and we got working on it right away, and let me tell you, Oakley and I had a ball.
So after using your paychecks to purchase this car, what went into restoring it?
A lot of blood, sweat, and tears. We spent a lot of time working on this car, and you know, Oakley was so passionate about it. They threw a good chunk of change into parts and stuff that we'd need to repair it, and it's crazy to see how we took a $1,000 junker and turned it into a really beautiful, true classic '67 Chevrolet Supersport.
So Ash, in your opinion, based on your observations and work on this car, did its value change?
Well, I sure hope so, because, I mean, again, it was a $1,000 rust bucket when we got it. But, I mean, when you see a 1967 Chevrolet Camaro Supersport roll in, you got to take advantage of that situation. And we put a lot of time into restoring it, put new parts on it for the body, got that engine up and running real smooth. I mean, I'd sure hope the value changed. I mean, even Mr. Aoki said that it was worth $83,000, so I'd like to agree.
Thank you, Ash. No further questions, Your Honors.
Cross-examination.
Yes, Your Honor. Mr. Espinosa, you pled guilty to conspiracy to commit money laundering?
Yes, I did, along with my cousin Harley Diallo.
That's right. You were involved in the scheme with him.
Yes. Yeah.
The money was laundered through Diallo's scrap and sale?
Yes, so how it worked was I would make the fake invoices at Trillium, and Harley would create the fake receivables at the junkyard, but this continued far past my involvement's ending.
Bringing you back to the start of this, you started working at the junkyard, correct?
Yes, after COVID hit, Harley had reached out to me about picking up some hours, so I figured, I mean, we needed a little bit extra cash coming in, and I assumed Harley needed a little bit of help given COVID.
And you became an owner of the junkyard.
I had helped Harley out through helping them switch over the financial system, and they were appreciative of it. So it wasn't much to me, but they insisted and pretty much told me to take a 20% ownership of the junkyard.
Now, you were offered this stake in part due to your help with the business end of the junkyard?
Yes, and I initially denied the offer because, you know, I didn't have the money to buy that 20%. I was trying to consolidate what funds I could for my family. But Harley insisted it, and it was kind of surprising to me because, you know, switching numbers from here to here it's not a big deal.
But to clarify, you were given this. You were given the stake in part due to your help with the business end of the junkyard.
They didn't necessarily say anything specifically. It was after I had helped them out through that. But they said it'd be considered sweat equity. So I assumed it was me coming and helping them out in the junkyard and salvaging the parts and everything after that too.
One of the things you did was create a new financial system using fixed books for the junkyard.
I didn't necessarily create the new financial system. It was already a thing. Fixed Books is a very great program. But they had everything on spreadsheets, and when I looked at those spreadsheets, that's kind of an unorganized and inefficient way of doing it. So I moved the numbers from here to there, and I thought it was very user-friendly, so I figured I'd help them out through that.
Speaking about the specific conspiracy at issue today, in November of 2020, a piece of machinery at the junkyard broke.
Not the whole machinery itself, it was the belt on it. But yes, November, the belt broke.
And that piece of machinery cost $3,000 to replace?
Again, I just want to be clear, it wasn't the whole machinery, it was just the belt on it. It was a $3,000 belt, though.
Now, this junkyard didn't have the money at the time?
At the time, it didn't. But it was interesting because the junkyard didn't seem to be taking as much of a hit as everybody else was for COVID. I mean, even the government was suffering
Mr.
more than it seemed
Espinosa,
the junkyard was.
I'm not asking you to speculate about the potential financial situation of the junkyard. As far as you're aware, the junkyard didn't have the money?
For a $3,000 belt, no, they didn't at the time.
So you created a fake invoice to Trillium High School?
After all the pressure and the idea being initiated by Harley, that's what we ended up doing and fell into the embezzlement scheme. I would create the fake invoices from Trillium, like you said, and then Harley created the fake receivables.
To be clear, Mr. Diallo never explicitly asked you to embezzle money from Trillium High School.
To me, it was pretty explicit. They told me to find funds in a creative way and brought up where I had access to funds. So I didn't know any other way to take it.
Mr. Espinosa, I'm not asking you to speculate about what Mr. Diallo might have meant. He never explicitly asked you.
I didn't say anything about what they meant. I simply said how I interpreted it. I took what they said and the looks they were giving me, the situation we were in, and that's how I interpreted it.
Your Honor, may my co-counsel approach opposing counsel with copies of Exhibit F?
Yes.
Let the record reflect that my co-counsel is presenting Exhibit F to opposing counsel, which has already been admitted into evidence.
No objections, Your Honor.
Record so reflects.
May my co-counsel approach the witness?
She may.
And let the record reflect that the same exhibit is being handed to the witness.
The record will so reflect.
This is the fake invoice you created for the belt?
Yes, this was the first fake invoice that Harley and I had created.
Now, to be clear, nobody else at the junkyard had signature authority over Trillium's bank accounts?
No, I was the only one who held a position at Trillium, and Harley was very quick to point that out.
This wasn't the last invoice you made?
No, it wasn't, because I cut everything off in December of 2021.
That's right. Over the next 13 months, you created fake invoices totaling $80,000?
Harley and I both, yes. By the end of that year, I guess 13 months, we had taken over $80,000 from Trillium.
Now, you believe that there was other laundering going through the junkyard after that?
Yes, that's what Harley was doing. And I guess it was, when I had cut it off, they said they had been doing it for a while, so I'm not sure how early this trails back to.
And as partial owner, you could have stopped it?
I could not have. I don't tell my boss what to do.
Well, you didn't go to the police about this.
That's my cousin. I mean, I wasn't going to turn my cousin into the police.
Well, Mr. Espinosa, I'm not asking about what you wanted to do. You could have stopped this by doing something like going to the police.
I guess by being a terrible family member, I could have turned my cousin into the authorities, yes.
You chose not to.
Because I love my cousin, I did not turn them into the police.
Now, I'd like to speak about the Camaro you mentioned on direct examination. In August of 2021, during the time you were embezzling money from Trillium, you purchased this car for $1,000?
Yes, I did.
Now, when you bought it, it was in pretty bad shape.
It was, and it's pretty crazy to see how far my boy and I brought it.
It needed a lot of work.
And it got a lot of work.
But it was never fully finished, was it?
We were 2 coats of paint away. We were real close. We got the body and the interior and everything up to where we wanted it. But I guess to a collector who would want 100% restoration, it might not be up to their standards, but it was pretty darn close to ours.
Mr. Espinosa, you just said that the body was good, but to be clear, it still needed some body work, right?
Very little, and we really only wanted to put a couple more coats of paint on it. But before we got the chance to do that, the state had taken it from Oakley.
Well, to be clear, it's not Oakley's car. The car is legally in your name alone.
Yes, that is true.
Now, you don't have any certification in auto repair?
No, I don't have any official certification.
And your son Oakley certainly doesn't either.
Not from my knowledge.
And you're not certified in any way in auto appraisal?
No, and I don't think I've claimed to be.
Thank you, Mr. Espinosa. Your Honor, I have nothing further. At this time, may I retrieve my exhibit?
You may.
Thank you.
Recross.
There you go.
Yes, Your Honor, but
Very
first
welcome.
may I inquire how much time I have left? 40 seconds. Very brief, Your Honor.
Yeah.
May I proceed?
You may proceed.
Ash, what did you originally suggest doing about the broken belt?
Well, I had originally looked at the finances of the junkyard to see if there was any money that could be moved around. And then I looked at my personal finances, and it was a little too tight to cough up $3,000. And then I proposed getting a loan. It's legitimate, viable options. Small businesses do that all the time when they're in a bind. But Harley shot them down very, very quickly.
So after shooting down your legit, viable options, what role did Harley play in the embezzlement?
Harley created all of the receivables, and they were the person to say that they could do that and cover up our tracks. And, yes.
Thank you, Ash. No further questions.
Anything else?
Nothing further, Your Honor.
You can step down.
Thank you.
Any additional evidence?
No, Your Honor.
Okay. I'll ask the timekeepers, were there any discrepancies in times? I tried to keep a close watch.
There was no time discrepancies or record cases.
Okay, that's correct. Are both sides ready for closing arguments then?
Your Honor, I believe pursuant to mock trial rules, we are entitled to a 2-minute period to
Oh,
prepare for
excuse me.
closing.
That's correct.
Thank you, Your Honor.
Timekeeper will keep the time, please.
Your Honors, opposing counsel, may it please the court. The defendant took action. And now he needs to take accountability. You learned today that the defendant and his cousin were involved in a money laundering scheme. They laundered $400,000 through the junkyard they co-owned. All but $18,500 has been repaid by the defendant and Mr. Diallo. We are all here today because the state is seeking forfeiture of the defendant's 1967 Chevy Camaro for the balance of restitution owed. There are two issues before this court today. whether the defendant was the conspiracy leader, and whether forfeiture of the Camaro violates the defendant's Eighth Amendment rights. As to the first issue, the defense has argued that the defendant is only responsible for the $80,000 he embezzled from Trillium, which both parties agree has been repaid. However, pursuant to Honeycutt v. U.S. and U.S. v. Leyva, the conspiracy leader is responsible for the entire amount of the conspiracy's loss. Today, we have the burden of proving by a preponderance of the evidence that the defendant was the conspiracy leader. U.S. v. Quigley set forth factors to consider in determining the leader of a conspiracy. These factors include decision-making authority, claiming a larger share of the profit, and control over others. Today, you heard from Detective Makani Kekoa. Detective Kekoa told you that the defendant has the financial background and sophistication to orchestrate this scheme. And she told you that she overheard the defendant calling the shots. Then you heard from Harley Diallo, the defendant's business partner. Mr. Diallo told you that it was the defendant's idea to launder money from Trillium. And he told you that when the conspiracy expanded, well, the defendant demanded a larger cut. The defendant took action. We have met our burden. As for that second issue, the Eighth Amendment to the United States Constitution provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishment inflicted. The Indiana Supreme Court held in Indiana v. Timms that forfeiture of property that is grossly disproportionate to the offense committed is an excessive fine. And today, the defense had the burden of proving this to you by clear and convincing evidence. This court has adopted the three-part analysis from Timms to assess disproportionality. First, the harshness of the punishment. The defense's expert witness, Presley Aoki, tried to convince you that the Camaro is worth $83,000. But then after admitting that the source of the parts in a vehicle are key to the value, Mr. Aoki stated that he doesn't know where the Camaro's parts came from. Second, the severity of the offense. The defendant's offenses are serious financial crimes. Crimes that enable other dangerous criminals, like drug dealers, to cover their tracks. These crimes are severe. Third, the defendant's culpability. To this point, Your Honor, the defendant has admitted his guilt. The defense has failed to meet their burden. We respectfully request that you order the forfeiture of the defendant's 1967 Chevy Camaro because he took action and now he needs to take accountability. Thank you.
Thank you very much. Defense counsel, you may make your final argument.
May it please the court. This is a case where Harley Diallo manipulated Ash Espinosa and conned Ash into becoming involved in Diallo's criminal scheme to save Diallo's business. Ash went along for the ride with Diallo and ended up being taken for a ride. At the beginning of this hearing, my co-counsel Charlie Height told you that the state would not be able to prove by a preponderance of the evidence that Ash Espinosa was the leader of this criminal enterprise. And the evidence supports this. In addition, we have shown by clear and convincing evidence that the forfeiture of Ash's 1967 Chevrolet Camaro would amount to an excessive fine in violation of his Eighth Amendment rights. Ash Espinosa is a hardworking, family-oriented man. When COVID hit and when Ash was struggling financially, Harley reached out to Ash and gave Ash work at the junkyard. It was here Harley manipulated Ash and convinced him to take part in Diallo's criminal scheme. Just as Diallo was the boss of the junkyard, Diallo was the boss of this crime. In the case of State v. Chavez, the Second Circuit Court of Appeals held that a leader is one who, among other factors, had the power to hire others, was responsible for foreseeable quantities of proceeds of the crime, and was organizing criminal activity that involved 5 or more participants. Here, Harley hired and recruited Ash at the junkyard. Harley was receiving a 20% cut of money laundered through the junkyard without Ash's knowledge. And Harley was organizing money embezzlement and laundering at his business amongst himself, bargain buddy, Ash Espinosa, and more than one business contact. Just as Diallo was the boss of the junkyard, Diallo was the boss of this crime. You heard from Ash himself today, who testified to the passive-aggressive looks and comments that were meant to pressure him into using his position at the school. Harley testified that he stopped embezzling in December. Meanwhile, Harley admittedly continued. You also heard from Detective Kekoa today, who glossed over the fact that she had no hard evidence, no paperwork linking Bargain Buddy to Ash Espinosa. Detective Kekoa did not provide an opinion to a reasonable degree of certainty on forensic accounting any legal opinions that Ash was the leader. They provided no basis to their claims. You also heard from Harley Diallo today. Harley Diallo testified that they gave Ash Espinosa a 20% cut in the business. And Harley Diallo testified that they were working with known criminals outside of Ash's knowledge. The second issue in today's case was whether or not this was an excessive fine. In the case of Timms v. Indiana, the Indiana Supreme Court held that the forfeiture of Timms' Land Rover was an excessive fine because it was worth 4 times what the state was seeking in restitution. The certified and experienced auto appraiser today testified that this car is worth more than 4 times what the state is seeking in restitution. Presley owns his own appraisal business and has been in that business for 24 years. Presley spent 38 hours evaluating this car. And he testified today in his expert opinion that more than 90% of the parts on this vehicle were OEM or new old stock parts. He conservatively valued this car at $83,000, leaving leeway for an even higher evaluation. The only expert, the only witness who testified today to the value of this car, the second issue of this case, was presented by the defense. The state has provided no witnesses to refute that. Furthermore, opposing counsel testified that Ash Espinosa took action. Ash Espinosa may have taken action, but Diallo took initiative. Ash was making the fake invoices, while Diallo was actively making the receivables. Ash had access to the funds. Ash was with known criminals, but Harley was the one getting a 20% cut. And Harley was the one working with more known criminals outside of Ash's knowledge. The court needs to evaluate this case and see the value of both the Camaro and the value of justice for Ash Espinosa. Accordingly, the defense asks that the court find that Ash was not the leader of this crime, and that the forfeiture of Ash's treasured car would amount to an excessive fine in violation of his Eighth Amendment rights. Thank you.
Thank you very much. Counsel for the state, you may make your rebuttal argument.
Yes, Your Honor.
Your Honors, Miss Greer just told you that the defendant was along for the ride. But I'd like to rewind a little further back. Because the truth is, Your Honors, well, the defendant started the car. The defendant had the keys to this conspiracy. Because the truth is that the defendant was the only person at the junkyard with access to Trillium High School's funds. The defendant is the only one who had the ability to create these fake invoices that were used to launder money. His name is the primary contact listed on both of these fake invoices. Your Honor, the defendant took action. And now, he needs to take accountability. We respectfully request that you order the forfeiture of the defendant's 1967 Chevy Camaro. Thank you.
Thank you. This time, the scoring judges will retire to begin their deliberations.
Joining us, we have our first student here. So go ahead and tell us, what is your name, school, and grade?
My name is Logan Adams. I'm from Archbishop Hoban High School, and I'm a senior.
Great. And how long have you been involved in mock trial?
3 years now.
Great. And what is your favorite thing about participating in the program?
Honestly, the relationships that you build with not only your team members, but your coaches and your legal advisors. I mean, it's truly a family.
That's great. And what do you feel like you have learned from the program?
I've gained a lot of confidence in public speaking and being confident enough to share my ideas with other people, and putting trust in other people that we rely on throughout these trials.
That's wonderful. And I'm sorry, did you say you were a senior?
I did.
Yeah, what are your plans for next year?
Next year, I'm hoping to go to Walsh University to study physical therapy.
Oh, that's great. And if a student was considering joining mock trial, what advice would you give them?
I'd say talk to Jared Top, because he'll convince you. But it's if they're thinking about it, I tell them go for it, because there are some hurdles that you have to get over.
Right.
And you learn a lot. And the more time you spend in mock trial, the more confident you'll become, the more rounded of an individual you'll become, and it's just all around good for preparing you for real life.
Oh, that's great. Well, thank you so much.
Thank you.
Yeah. Hi, how are you? Good. All right. All right, we have our next student here. So go ahead and tell us, what is your name, school, and grade?
My name is Charlie Height. I am from Hoban, and I'm a senior this year.
Great. All right. And how long have you been involved in mock trial?
I've been doing mock trial with Hoban for the last 3 years.
Great. And what is your favorite thing about participating?
Obviously, actually getting into doing the hearings and the trials is very exciting. It's fun to talk in front of people, but I think the most important part, to echo what he said, was building relationships on your team. It's a family, you know. Our team's a family. It's part of the Hoban family, and it's incredible to create that tight bond through the course of the season.
Yeah, it was great seeing that. And what do you feel like you have learned from mock trial?
Kind of similar to that last answer. I feel like mock trial has taught me a lot about relationships, you know, how to talk to people, how to talk in front of people, but, you know, how to establish a connection with the people on your team, even the people you're going against. I think it's huge for teaching individuals how to become a part of a community.
Yeah, that's great. And what are your plans for next year, since you're a senior?
Next year, I will be going to the Ohio State University.
Wonderful.
And majoring in business.
Oh, that is so great. And if a student was considering joining mock trial, what advice would you give them?
I think a lot of the hesitations that people get when they're considering mock trial is they're, you know, not so certain that they're going to go into a career with law or a career in that department, but you know, I'm obviously not considering law, but I think it is a universally applicable thing to chunk on your resume, to chunk on your experiences. What you're going to get out of mock trial is public speaking, relationships, you know, exposure to a completely different realm, and I think it's going to help build your diversity and help build you as a person for whatever you want to pursue.
Right. You're so right. Well, thank you so much.
Thank you as well.
Hi.
Hello.
All right. Go ahead and tell us, what is your name, school, and grade?
My name is Lindsay Henry, and I'm a senior at Archbishop Hoban.
Great. And how long have you been involved in mock trial?
I've been doing mock trial for 3 years.
Great. And what is your favorite thing about participating in the program?
I would say, like the rest of my peers' family, one of the most important things about Hoban is we all say that we're one big Hoban family, and without doing mock trial, I wouldn't have my best friends here with me.
Oh, that's great. And what do you feel like you've most learned from mock trial?
I would say the biggest part is law. Without learning about, without doing mock trial, I would not know about any of this, and I think it's so important to know, but also I've learned how to speak publicly, and before this, I really was not that confident in doing that.
Great. Yeah, I know. That's so true. And did you say you were a senior?
Yes.
Okay. What are your plans for next year?
Next year, I plan to go to Akron University and study criminology and philosophy.
So great. All right. And if a student was considering joining mock trial, what advice would you give them?
I would say you should 100% go for it. Mock trial is one of the greatest memories I have from high school, and I think everybody should do it.
Oh, that's so great. Well, thank you so much, and congratulations.
Thank you.
Hi, how are you?
Hi, I'm good. How are you?
Good. All right. Go ahead and tell us, what is your name, school, and grade?
My name is Rachel Greer. I go to Archbishop Hoban High School, and I'm a sophomore.
Okay, great. And how long have you been involved in mock trial?
This is my second year.
Oh, wow. Okay, great. And what is your favorite thing about participating in this?
Of course the trials are super fun, but my favorite thing is probably the work that goes into it. We practice a couple times a week for a couple hours on end, and I really like getting together and working, and we hang out after. It's a lot of fun.
Oh, that's awesome. And how do you feel, or what do you feel is the biggest thing you've learned from mock trial?
The biggest thing I've learned from the start of the year, it was a couple practices in, our coaches said you get out of it what you put into it. Yeah. So I think the discipline part of mock trial has been a super big aspect for me.
Yeah, that's so true. And you said you're a sophomore, so I won't ask your plans. You're still going to be in school. Okay, and great. So if a student was considering joining mock trial, though, what advice would you give them?
I would tell them to do it. A lot of the people that I'm here with today are some of my closest friends now, and I feel like I wouldn't have gotten them if it weren't for mock trial. It brings together a super unique group of people, and I know I'm echoing everyone, but at Hoban, family is super important, and it really is like a little family, especially our legal advisors and every member on the team.
Oh, great. Well, thank you so much for interviewing with us, and congratulations. Hi, how are you?
Good. How are you?
Good, okay. Go ahead and tell us, what is your name, school, and grade?
My name is Grace Fricker. I am a senior at Archbishop Hoban.
Okay, great. And how long have you been involved in mock trial?
I have been in mock trial all four of my years at Hoban.
Oh, that's so great. What is your favorite thing about participating?
My favorite thing, just to echo what other people have said, was especially the practices that we go to. We put in a lot of time and effort, but we also put in a lot of heart and a lot of empathy towards each other, and the community that I've built around mock trial is by far my favorite people at the school.
That's so great. And what do you feel like you've learned from mock trial, or the best thing you've learned?
Well, I feel like, mock trial has taught me a lot, but I feel it's most important that it has educated both my heart and my mind, seeing as it's taught me to work well with others, but it has also taught me about the facts of cases and public speaking, like everybody else has said.
Yeah, that's so great. And what are your plans for next year?
Next year, I am planning on majoring in nursing.
Oh, great. And if a student was considering joining mock trial, what advice would you give them?
I would tell them to absolutely do it, because the community we've built around mock trial is phenomenal, loving, caring, and so informative.
Well, thank you so much, and congratulations. Thanks. All right, go ahead and tell us, what is your name, school, and grade?
My name is Hannah Madison, and I'm a senior at Springfield High School.
Great. And how long have you been involved in mock trial?
Ever since the fall of my freshman year, so 4 years now.
Wow, okay. And what is your favorite thing about participating in the program?
I think my favorite thing is just absolutely the connections I form, not just with my legal advisors, but with my teammates. And my very favorite thing is seeing those connections manifest during trial. There's been so many times this season where I'll start to write down an objection to give to my co-counsel, but they're already standing up and making it, and it's just so cool to see that we're always on the same wavelength and we just understand how we want the trial to go.
That is so great. And what do you feel like you've learned most from mock trial?
I think that our coaches have very much instilled in us just a knowledge of our own rights. Obviously, we're learning about the law, but they also have just encouraged us to stand up for ourselves in any sense. You learn how to public speak through mock trial, but that manifests itself in so many other ways. So I feel that I'm able to just apply everything that I've learned and the confidence that mock trial has given me in every aspect of my life.
Oh, that's so great. And so what are your plans for next year?
I haven't decided on a school yet, but I'm hoping to double major in art history and philosophy on the pre-law track.
Oh, that's so great. And if a student was considering joining mock trial, what advice would you give them?
If they're wanting advice for how to prepare for mock trial, let's say if they're younger and they don't have a mock trial program yet, I'd tell them to get into theater while they can. That's how I started, and so much of mock trial is just performance, confidence in front of other people. So if they want a head start, they should get on stage.
Oh, that's such great advice. Well, thank you so much and congratulations.
Thank you.
Thanks.
I'm good. How are you?
Good. Okay. All right. Go ahead and tell us, what is your name, school, and grade?
Hello, my name is Ben Ehlers, and I'm a senior at Springfield High School.
Great. And how long have you been involved in mock trial?
This is my second year.
Great. Second year. And what is your favorite thing about participating in the program?
For sure, the teammates, not just the senior teammates who competed with me today, but my team Gold, who was able to see us today, and Team Blue, who's back in Springfield. I love all of them.
Oh, that's so awesome. And what do you feel like or the most important thing you've learned from mock trial?
I think it's good. I sometimes talk before I think, so I've learned to slow down and really think about what I'm saying before I say it.
Awesome. And you're a senior, so what are your plans for next year?
I don't know my plans for next year. My plan for the next 2 weeks is to hear back from all my colleges, and I'll figure it out from there.
That's great. And if a student was considering joining mock trial, what advice would you give them?
I would say do it 100% effort. I think it's worth doing no matter what, but you get exponentially more out of it what you put into it, so it's worth to go all in.
Thank you so much, and congratulations.
Good. How are you?
Good. All right. What is your name, school, and grade? Go ahead and tell us.
My name is Melissa McMahon. I go to Springfield High School, and I'm a senior.
Great. And how long have you been doing mock trial?
Ever since my freshman year, so for 4 years.
Oh, wow. And what is your favorite thing about participating in the program?
I feel like everyone else has also said this, but the family thing is really so prevalent. Yeah. It's like my coach's house has become like my second house. I'm over there so much for practices. And I think there's also the education aspect of it, because I would never know how to go about a restitution case or anything like that. And because I want to be a lawyer, it provides you with so much pre-information in that sense.
Yeah, absolutely. And what do you think is the best thing you've learned about being in mock trial?
I think the public speaking aspect, I kind of still do it, but I used to talk really fast. And this, my coaches will tell you, just slow down. You can never speak too fast, and you can never speak too slow, I mean.
Yeah, sure.
I was talking too fast already. Mock trial, because your public speaking skills helps you in all aspects of your life. So this is just a place where you're forced to use that. Right. And again, the education sense in terms of law.
Oh, that's awesome. And so since you're a senior, what are your plans for next year?
My top school right now is Ohio State, and I want to double major in criminology and psychology, and to go on eventually to go to law school.
Oh, that's amazing. And if a student was considering joining mock trial, what advice would you give them?
Do it. if you're debating, do it. And like my teammate said, this really is theater and law. I did not join this for the theater part, but it's like a subsequent thing. It's automatically integrated. So whether you like theater or like law, it really helps you in both senses.
Okay, well, thank you. Thank you so much, and congratulations.
Hi, I'm good. How are you?
Good. All right, go ahead and tell us, what is your name, grade, and school?
My name is Joel Bloom, and I'm from Springfield High School as a senior.
Okay, great. And how long have you been involved in mock trial?
Since my freshman year, so 4 years.
Oh, 4 years. And what is your favorite thing about participating in this program?
It's been repeated a lot, but I gotta say it's my teammates. Being able to grow and develop alongside them in those 4 years is truly fantastic to just witness the changes we undergo.
Yeah. And what is the best thing you've learned about being in mock trial?
I have two things.
Go ahead.
First is how to rationalize an argument and base it on evidence, not just opinion. And then I'd have to say it's public speaking, how to speak in front of a crowd, or in my case, speaking in front of a camera and a crowd. But as a personal experience, I was in speech therapy for 7 years of my life, and now I'm up here speaking to all of y'all.
That is so awesome. And since you're a senior, what are your plans for next year?
I'm not settled yet, but I'm planning to potentially attend the Virginia Military Institute for International Studies with a minor in National Security.
Wow, that's great. All right, if a student was considering mock trial, what advice would you give them?
Do it, or as I told my brother, do it or else.
That's so great. Well, thank you so much and congratulations.
Thank you.
All right, so that is all we have from the students. So now we are going to learn more about the mock trial program. Thank you so much.
Welcome back, everybody, and congratulations again to the teams. I am going to turn it over to the judges to provide some feedback on your performance, and then we will get to the much anticipated awards portion. So, Judge McBride, if you want to begin. Thank you.
So, you can be seated, incidentally. Unless you prefer to stand, that's fine. We'll start at the right side, if you would proceed.
Well, first of all, congratulations, students and all the legal advisors. You know, I judged the first round, and to see the difference in level between the championship and the first round has been quite impressive. To all the attorneys, you did a wonderful job. I can tell you right now, you would not be out of place in a federal court. The way you have commanded kind of your scene and your different perspectives, really amazing. For both of you, you did great job in terms of incorporating your theme throughout the course of the trial. I will say from the state, that action to accountability, that is directly how a prosecutor would see this action. So you did a great job kind of embodying the role of the state and the righteous indignation. I particularly loved the talking about how money laundering, it also covers for other significant crimes. And sometimes we don't think about that enough. And as a prosecutor who does a lot of complex financial fraud, I thought that was right on. For the defense, that went along for the ride and instead was taken for the ride. That was an excellent use of theming. I also loved how, in the end, Rachel, you responded to the prosecution's team, and then you said, okay, he may have taken some action, but Diallo took the initiative. That was spot on in terms of your playing off of the theme. So really well done to you guys. In terms of witnesses were all excellent. I loved the little things you did to kind of throw in your personalities and really embody the characters, from wearing a detective lanyard, from saying, you know, it's a long story, when talking about how, you know, a cooperating witness, and kind of, you know, saying a little bit of why you were also, you know, you two are not the best actor here, but you are saying that now you're here with a plea agreement that says you're telling the truth. That, you know, spot on for how you should characterize any kind of cooperating witness who has some character flaws. Similarly, on the defense side, love the car enthusiast, pure American muscle on the car, spot on. I love that. The AAA for short, also love that. So great job, really like selling the you are a car person. similarly, the defendant. I thought you stayed in character throughout. You did a wonderful job. I think throwing out, "That's my cousin," that was very credible for your character. And I think, in general, that's how you would want your defendant to act. Really spot on. So I just want to congratulate you guys, especially your making objections, responding to objections. You really learned the rule of evidence, and that's so important. But I just want to say broadly, I don't know if people are thinking about law school or if you're not thinking about law school but just thought this would be a fun exercise. I really encourage you, whatever you do in the future, the Constitution matters, and being able to know and understand the role we have as citizens is incredibly important. So I commend you all, and good luck to you in the future.
Thank you.
Thank you.
So I'll begin by just saying, I don't know what my facial reactions were at any given moment, but I was having a blast. This was so much fun. It's fun for someone who is on the committee of people to come up with the case. You come up with an idea, you have to come up with the, find the case law, write the witness statements, do all that sort of thing, and then to see it basically brought to life. You guys were probably very nervous. I hope you had half as much fun as I did in addition to your nerves, because then it will have been well worth it. I'll offer I want to highlight one thing for the attorneys and one thing for the witnesses that I think was good, that basically the attorneys did well on both teams and that the witnesses did well on both teams, with an eye toward the fact that one of you will be competing at nationals, and then hopefully you all will also be back in years to come doing mock trial in high school, college, wherever. So these are things you did well that you can carry forward with you. I think starting with attorneys on objections. So I think the most difficult part of an objection, if you're in my shoes, you're trying to judge, you're trying to understand what's going on, is following the logic of the objection. And so when you write your opening statement or your closing argument, I'm sure you have a legal advisor who might have told you to do issue, rule of law, analysis, conclusion as a form of writing it. Try to conceptualize the objection as similar, where there's something that the witness has said that's bad, or there's a question that's been asked that's a bad question, or you think something might be said in the future by the witness that's not good, that you want to keep out. So those are kind of like the three things that you might object to, that you might want out. But oftentimes in the objection, the attorney will jump right to the rule part of it. They'll go right to Rule 702, or, this is why Rule 702 applies, or this is why Rule 403 applies, where the judge here, it's like, wait, what did the witness say that is being objected to, or what was the question? I can't remember what the question was. So a really, really well-made objection, which, again, this is something you all did very well, will highlight what the issue is before it gets into the application of the rule and why the objection should be sustained. So, like, the witness said this, that is objectionable because of this rule. Or, I think that this question will ask the witness to say this. It's the this that makes it so much easier to follow the objection. So carry that forward with you at nationals or next year or whatever, but that would be if you go back and look at the tape, this might be on YouTube one day, you'll see that you all did that over the course of the trial. Keep doing it. You did a very good job with it. With regard to witnesses, it's tricky, I think, to balance. If I'm a witness, I was never a witness, and hopefully I'm never a witness in court or whatever, but balancing your aggressiveness with the cross-examining attorney's aggressiveness. So if you're a character witness, you're Ash, and you're being, this car that you love is being taken from you, then maybe you have more of a character background to be indignant about what's going on than, say, an expert witness who has to be impartial or maintain more credibility. Not that Ash doesn't have to worry about his credibility, but think if you're a witness as to, like, do I want to be more aggressive than this attorney in the questioning, or do I want to always be a little bit less aggressive than the attorney is in the questioning? So I always kind of think of it when I'm watching this as like, the attorney is like on the scale of aggressiveness with their cross, and the witness is here, and who's higher than who, and who should be higher than who. And a really good cross-examining attorney and a really good witness will battle with each other because they'll both know who has to be the more aggressive one, and they'll both try to prevent the other one from getting the upper hand. So, and again, it's tricky because it depends on what sort of witness you are. You're a character witness or you're an expert witness. But think about that when you get the witness statements for nationals, you get the witness statements for the 2025 Ohio High School mock trial case, and approach it that way. I'll close by saying, again, I had a blast. I was in your shoes 14 years ago. I don't remember a single objection I made or a single word I said. I just remember that it was a lot of fun. And I hope 14 years from now, you all will similarly remember that you had a lot of fun today.
So a couple thoughts. First of all, please remember to each of you, when you get done today, to say thank you to the folks who are sitting on either side, who've supported you, who've been there. The proverbial, it takes a village, and I appreciate that. The next thing I'll say is I have been very fortunate in my career to try cases literally all over this country, principally in federal court. I will take each and every one of you and have you second chair any case that you want. Name it, you can come do it. Because you're that skilled and you're that professional. And know that no matter what career you choose in life, and I will tell you as the state bar president, we don't have enough lawyers. I hope you all want to be lawyers. As the chief, I know, made some remarks to you earlier. Know that whatever you do, the skill that you've just picked up, the ability to think, to work, to talk, to work as a team, to work effectively as a team, and ultimately, I've had to add this, obviously, in the last few years, the civility in which you showed and the respect in which you showed each and every one of you is something that no matter what you do in life, that will serve you well. So congratulations to each one of you for doing that, because you did it well. And congratulations for not falling off that podium, because let me tell you, if it had been me, Rachel, you and I are in the same, we have a same stylistic point. So congratulations for not falling off, because if I'd been wedded to that, it'd been tough. The things that I certainly was looking for, obviously there's a presence, there's a poise that comes with being a trial lawyer, to be in this setting, whether you're a witness, whether you were one of the attorneys. Poise comes to mind. Again, I think it's going to serve you well, and each one of you exhibited that. Some of you differently than others, but all very effectively. I was looking for things like transitions in and out of objections. As a lawyer, spent a lot of time behind that podium. When those objections come, how do you handle them? How do you pivot? How do you respond to them? And I thought all of you transitioned very, very well, even as the witnesses. Obviously, you're having to have a cue to what the judge is telling your lawyers about the objections, and each one of you took those in stride. I would suggest stylistically, particularly on cross, short, pointed questions, keeping those very tight. That's the best way to control witnesses. I think all of you had witnesses who wanted to have a little bit of a conversation today. And I can assure you, there are very few judges I appear in front of that would have let some of that go on. But I thought your objections were well-timed, well-structured. I saw good pivots in and out of those. The only caution I would give to you is be careful as you make those objections that you don't give opposing counsel an opportunity to reiterate a positive point for them. There was a point I noticed that an expert witness was given an opportunity to really expound on that individual's credentials. That's a second chance for a judge or a jury to hear what you probably didn't want to have heard. So, but overall, again, I am very impressed, thrilled to have an opportunity to see all of you at work. And again, whatever you do, this is a great opportunity. I obviously, a very long time ago, had an opportunity to do this. And by the way, having been born in 1967, thank you for all the gem references to that. I'll just take those as a compliment. But again, congratulations to each and every one of you, because quite frankly, as I said, and I meant it, I would love to see all of you continue on these particular paths. And congratulations to each and every one of you on the work you did. So thank you.
Congratulations to both of you. Great job with everything you did today. I had an enjoyable time as well sitting on this side. A couple things I'll say as a non-traditional legal professional. I looked a lot at how you continue to assume your role even when you weren't in the spotlight. And I thought that some good feedback to give is that even when you're not the person that's speaking or you're not the person that's being questioned, remember you're still in character. But I thought everyone did a great job with that today. Just something to kind of keep in mind as you move forward and continue to participate. Some advice I can share with you is that programs like this, and I want to send an exceptional thank you to the Ohio Center for Law-Related Education and their staff for continuing to put on an amazing program like this. I'm in the Cleveland area. One of our committee chairs for this committee is an actual mock trial graduate. She went to States, and so this program actually works. So I would encourage you all, no matter what profession you choose, continue to stay involved with your local, state, and national organizations like this organization or the bar associations. They are there to help you facilitate what you want to do, even if it's not in the legal career, but if you're in the legal industry, these are great associations to just kind of get engaged with. They are there to help facilitate your growth and your matriculation through law school, if that's what you choose. So again, an amazing job today. I really want you to be proud of the work that you did, because you've done a great job, and thank you to the legal advisors and teachers who've helped as well.
I'm not going to try to repeat what everyone has said. This is the 30th year I have been a judge in mock trial. And the first year I did it, actually, the way I got started is an attorney who was involved in mock trial said to me, I was a young judge at the time, said, this is a program you really should get involved in, because you can't believe how well the students perform as attorneys and witnesses in this program. And every year that I come back, I'm continually amazed still at how good of performances you make in the roles that you're playing, and it's just I don't want to say it keeps getting better and better, but it's certainly good every single year, and this group is certainly no difference. It's really a pleasure being a judge in this. From the championship, obviously, is a real pleasure, but judging the earlier rounds is a real pleasure too. And you did a wonderful job. I agree, whatever fields you take. I have 4 children. They're not all attorneys. 2 of them are attorneys, 2 are not, but the programs that they have participated in, 2 of them participated in mock trial, but they all participated in programs like this. And it really helps when you get to college and grad school and beyond. So you will benefit from your participation in the program. You did wonderful today and are to be commended. And then my role is also to thank the people who are on the sidelines here, which is the attorneys and legal advisors never get quite enough credit. If you would raise your hand or stand up, and so we can. I once asked a legal advisor how many hours they put in with their team, and I'm not going to mention the number of hours, but it's astonishing. And I know it starts in about October and it goes all the way through now. And the students are putting in lots of time too, and it's wonderful. I want to recognize parents and friends who are here in support of you. They did a great job. You should be very proud of them, and certainly your support of their participation in this program has been very significant. So, great job. And we'll move on then.
Thank you. Thank you to the judges for giving up your time, coming to Columbus for many of you, and for giving so much attention and care to this. So thank you to our judges. Before I present the awards, I do want to take a moment to also thank the Ohio Center for Law-Related Education sponsors. So this program would not be possible, OCLRE would not be possible without the support of the Supreme Court of Ohio, whose building we are in today, and we're graciously allowed to use the space. Thank you also to the Office of the Ohio Attorney General, the Ohio State Bar Association, the American Civil Liberties Union of Ohio Foundation, and the program is also made possible in large part by grant funding from the Ohio State Bar Foundation. So thank you so much to our sponsors as well. And I won't delay this part too much longer because I know this is really why you're listening. So at this time, I'm going to present the James E. Phillips Outstanding Attorney Award. So congratulations to this year's James E. Phillips Outstanding Attorney, Hannah Madison from Springfield. Congratulations. Congratulations. And I would also like to present the Outstanding Witness Award. So congratulations to this year's Outstanding Witness, Melissa McMahon from Springfield. Can you hold this for 1 minute? Okay, congratulations again to everyone, and I echo the thank yous given by our judges to all of the supporters here today. And now the moment you have really all been waiting for. After 3 days and 5 trials, the winner of the 2024 Ohio Mock Trial State Championship is Springfield High School. Congratulations to Springfield. And congratulations to the runner-up, Archbishop Hoban. We would also like to recognize each individual student. We know that only one side of the case performed today. So if I could have an advisor from Springfield come up to present. We have gavels for each student, so I will let the advisor introduce and present the gavel to their students.
Thanks, Danielle. Thank you, everyone. Before I introduce my team, I do want to just quickly a few thank yous. First of all, thank you to our panel of judges. Thank you so much for giving up your time, the wonderful feedback. I could tell how engaged you all were, and it was just a wonderful round to watch. I want to thank our opponents, Hoban, and your coaches. This was an incredible round. It was great. I want to thank Springfield High School, the board, the administration, the teachers who give us endless support, the community, the parents, everyone who's here to watch. Our teacher advisor, Keith Fry, thank you so much for all that you do. Megan Farley, who is not only my co-coach, but one of my very best and dearest friends, thank you so much for all you do. And last but not least, my husband. As much as I am the team mom, he is the team dad, and he picks up all the slack at home when I am busy with the kids, and I am eternally grateful for everything you do to support us. Thank you. But it's not about me, it's about the kids. So come on up here, everybody, come up. Do I hand them to them? Okay. Okay. All right. First, we have our timekeeper bailiff, Caroline Yance, who is a freshman. Thank you. Melissa McMahon, a senior witness and also attorney on the other side of the case. Hannah Madison, a senior double attorney on both sides. Ben Ehlers, who's also a senior, but only his second year of mock trial, and he is an attorney and plays Ash Espinosa on the other side of the case. And last but not least, Joel Bloom, double witness, who plays Harley Diallo and also Presley Aoki, Springfield High School. Thank you. Great job, guys.
Congratulations again. If we could have an advisor from Archbishop Hoban come and present the students with their gavels.
Hi, so I'm Carol Tran. I'm one of the legal advisors for Archbishop Hoban. First of all, thank you so much to the judging panel for your time in judging this round. Also, thank you to OCLRE for the opportunity that is provided to all of these schools. Congratulations to Springfield, of course. And then as for our students, if I could have all our attorneys and witnesses come up. First one is to Logan Adams, obviously portraying Ash Espinosa. And then to Gavin Fabish, who portrayed Presley Aoki. Our defense attorney, Charlie Height. Defense attorney, Rachel Greer. And then for the other side that did not go today, first of all, Kate Folk, who is a attorney for the prosecution. And then we have Lindsay Henry, who was portraying Detective Makani Kekoa. We have Carolyn Rinaldi, who is one of our state attorneys. And then also to Grace Fricker, who portrays Gray Obasanya. And last but not least, our wonderful bailiff and timekeeper, Erica Leslie. Thank you so much.
Congratulations again to all of our teams, and thank you to our panelists, to our teachers, attorney advisors, parents, and the entire community that's been supporting these students all along the way. This was an amazing trial for us to watch, and as always, you have all been so impressive today. And that concludes the 41st Annual Ohio Mock Trial State Championship. So thank you, everyone. Congratulations, and a round of applause.